So in other words, you were saying she has approximately 48 days worth of work to do, assuming that those are 8-hour days? That's
Correct.
384 hours?
Yes. Yes, Your Honor.
What is the compensation rate per hour for mitigation experts under
I believe
the statute?
I'm sorry, Judge. I believe they're $50 an hour.
What says JAC?
Your Honor, there is some concern that the mitigation specialist apparently resides in Minnesota, and there's extensive travel costs sought. In fact, counsel's indicated in his estimated case budget that he anticipates some $11,120 to be spent solely on travel. And clearly, Your Honor, if there was a local provider, that would not be an issue, and that would not be a taxpayer expense. Again, if the court determines that the work done by this expert is such that it cannot be duplicated and that the work must continue, certainly we'll defer to the court in that. However, this is an Orange County case, and I would imagine that any material relating to mitigation would be here in Orange County, and that a local mitigation specialist could do that work without the need for any travel expenses other than perhaps mileage. Therefore, we're objecting on that basis, Your Honor.
Mr. Baez, where would these 300 and plus hours be spent? You say she's halfway done. Where's the rest of the mitigation stuff done? Is it in state or out of state?
There are some that are out of state, but a majority of it is in state. Ms. Barrett flies here on Southwest Airlines, and the average ticket that she utilizes is approximately $224. I believe Miss Anthony has family in North Carolina as well as Ohio. I think there are still a couple of trips that need to be done there, which she would be closer to anyhow. But what's important for Miss Barrett's work is not only to speak to these people, but to also go back and speak to Miss Anthony as to her relationship with these individuals and how that affected her upbringing and so forth and so on, and how close are they to them. She's also gone back and spoken to elementary school teachers and so on and so forth. She's done a very thorough job, and she just quite frankly needs to continue. I certainly believe, based on $224 a flight and some minor other travel incidentals, that it would be much more costly to start from scratch. It would also definitely delay the trial because you would have to do a whole year of mitigation again, and quite frankly, I don't think she could be replaced.
Well, nobody's irreplaceable. She has gathered whatever she's gathered. The question is whether or not somebody else other than her can do part of it here in Florida as opposed to her doing it all. But I have a question, but may the attorneys approach the bench at sidebar? Okay. JAC, anything else on the mitigation specialist?
Only to point out, Your Honor, that as Your Honor may be aware, the legislature has instituted new rates effective July 1st of this year, and the rates for investigators are, pursuant to JAC policies, the rates for mitigation specialists, and just wanted the court to be aware that that rate was going from $50 down to $40.
You understand that, Mr. Bias?
I understand if she wants the extra $10 an hour, she's going to have to come down sooner.
Well,
No, we totally understand, Judge, and Ms. Barrett's committed to Ms. Anthony's cause, and I don't anticipate any problems whatsoever.
one of the things she needs to do is to keep detailed time records. And one of the things I'm going to want time records as to people that she's interviewed in the past to make sure that there's no duplication. Judge Susan Schaefer from the 6th Judicial Circuit, who's now retired, who taught the death penalty course for a number of years, would often start that course off with the statement, death is different. And while I recognize the fact that we would have liked to have a in-state mitigation person, the state of Florida has indicated that it is seeking the ultimate sanction in this case. If the defendant is found guilty of murder in the first degree, there are only two possible sanctions: life imprisonment without possibility of parole, or death. Those are two of the most harshest punishment known in a civilized society. It is apparent that your mitigation specialist, Ms. Barrett, has put in substantial time, but I caution you that I will go over her billing with a fine-tooth comb. JAC will go over her billing with a fine-tooth comb, and it may get cut. But at this stage, where we are about 1 year out from a trial date that I've indicated that I'm going to hold you to, I'm not going to change your mitigation expert now. Remember, as the attorney from JAC, the rate goes down to $40 an hour when?
July 1st of this year.
July 1st. And she will be held to that. I will scrutinize travel. I will scrutinize the hotels that she stays in. Courtyard by Marriott, Hilton Garden Inns, and things of that nature are the type of hotels I would expect for her to stay at the cheapest possible rate, and she will be governed by the same per diem rates as outlined in Florida state statute. Also remember that if she rents a car, under the guidelines, I believe those are supposed to be compact cars, I believe. If she wants something bigger than that, she pays the difference. Okay?
Understood.
So your request for the mitigation expert to keep that one will be granted. Any other ones?
The only other one that I believe we had was the out-of-state investigator. And this I actually believe the JAC allows for. If there are out-of-state witnesses, we have an out-of-state investigator just for those witnesses. We plan on using an in-state investigator for everything in the state of Florida. And I just wanted to make sure that there were no issues with that. So that's the only reason I included it in my motion.
Okay. Yeah. Well,
But I think I needed to get a court order saying that was permissible.
for investigations in the state of Florida, you're going to have to use an in-state investigator. I'm quite sure you and Mr. Mason have investigators you customarily use here, and they will be bound by the rates set by JAC. Anything else in your out-of-state investigator, my suggestion is if there needs to be some investigation, get one local in that area. Investigators usually call people that know the locale where they are to eliminate travel costs for someone flying somewhere. Particularly when all you're going to do is pick up records, and sometimes you can secure those by phone.
We'll certainly make sure that we are as frugal as can be, particularly in the investigative area, which is quite an exhaustive process, specifically in this case.
Okay. Anything else dealing with the public witness?
Just one minor question that I had for the court. I realize it is a policy of the JAC that we file a motion for transcripts for each and every deposition that we do. Is Your Honor, I guess I have two questions. Is Your Honor going to require a hearing on those, or could we just do those on the pleading? And I guess the second part of my question would be, would it behoove us to just file one motion for transcripts on depositions on the witnesses we take, or would Your Honor prefer that we do them?
JAC?
Yes, it's true, Your Honor. We would require that every request for depo be asked for specifically, for a deposition transcript be asked for specifically, and the court review the necessity and reasonableness of that request on a case-by-case basis, and the request be by deponent and date of deposition. I would like to add, request one other thing, Your Honor, regarding the investigator, if the court would consider establishing a spending cap for the investigative services, at which point, if that cap is reached, counsel may come back and request more.
Suggest one.
I'm not sure how many hours of out-of-state investigation you may be requiring here. I would say something reasonable would possibly be 30 hours, 50 hours.
30 or 50 hours, I can tell you that's not going to work, not with this case. Mr. Baez,
I would agree, Your Honor. Not only that, we requested AccuSearch records. I hate to keep bringing this up.
Now, let's stick with the question. How many hours for out-of-state investigation are you requesting?
If I can have just a moment, Judge. For out-of-state, I estimated 100 hours, and there's a large unknown there, and I can tell you that has to do with the AccuSearch records that we don't have, which a good percentage of those people came from out of state to search for Caylee Anthony, and depending on what we get in those records, it will affect whether we need to speak to these people or not. So I guess a good starting point would be 100 as a cap.
JAC?
If the court finds that reasonable, we won't object to that.
I do not find 100 hours to be unreasonable. That's for out-of-state investigative, because in-state, Mr. Baez?
In-state, Judge, I had calculated 480. And I'll tell you how I came up with that number. If Your Honor recalls, I'm just trying to find my, if Your Honor recalls, the state had indicated 250 witnesses on the witness list, and approximately 90 of those would be deposed. So what I did was I excluded those 90, and I gave an average of 3 hours to interview or to research the remaining witnesses, and that's where I came up with.
Let's stop. When you say interview, what are you talking about?
Perhaps for example, instead of deposing someone, to go there and speak to one of the witnesses to see if there is actually something that they have that's relevant to the case, finding them, speaking to them, interviewing them, and maybe doing research on that specific witness. These are all things that may happen for the witnesses that we do not depose, because of course we don't have the benefit of taking their statements via deposition. Well, we do have the benefit. What I'm saying is, Judge,
you've lost me. You're doing a deposition schedule.
Correct.
And you have 2 weeks to put that together. Are you saying that you're going to choose not to take their deposition? And what happens if your investigator goes out and they say, I'll be happy to talk with you, but I want to talk to you through a deposition?
Then that's the route we have to take. What I'm trying to convey to the court, Your Honor, is out of, let's say we take 90 depositions, that leaves us with 160 witnesses. I would not just completely ignore, I don't think I would be doing my job if I completely ignored the other 160 witnesses. I would ask my investigator to investigate these 160 witnesses and the relevance that they have to this case, and to see, even though I know I'll be working with the state closely as to determining who these 160 people are, we certainly think it is our job to investigate each and every witness in this case. And what I did was I calculated just 3 hours per witness as a safety net, whereas we're certain some may take more, some may take less to determine that they're relevant. So that's the guide that I used when coming up with that number.
Well, let me ask you this. Of all the witnesses that have been listed by the state of Florida, did they either give statements or what these folks witnessed was regurgitated in some written form in a police report?
I believe some have, and others, but out of the 160, probably none of them have. We're still working on that right now. With their names may have been listed on a police report, but not supplements filed and things like that, where they've stated everything they've done. And I can tell you, based on our experience in this case, because it's been so long, such a long case, and the amount of time that's passed and the continuing investigation that's ongoing, that these reports are not complete as to each and everything done by these witnesses.
Well, Justice Marshall in Ake versus Oklahoma stated the following: that while the court has not held that the state must purchase for the injured defendant all that the state assistance that his wealthier counterpart might buy, see, or use, the only thing that is guaranteed is an adequate opportunity to present their claims fairly within an adversarial system, which translate that it must be reasonable and necessary. At this particular time, I'm going to cap you at 300 hours. When you get there and you need to exceed the 300 hours, then you're going to need to come back and justify it. But for right now, I'm going to give you 300 hours. You can use it as you please. But once you use that and you want more than that, you're going to have to justify it. because we're talking about public taxpayer dollars.
Understood.
Okay?
Yes, sir.
Now, you said there were some things that, you can be seated. You said there were some things that you wanted to take up in camera?
Yes, Your Honor.
Okay. Let me ask you this, and I'm going to give the state an opportunity to state their position. How many of these experts are you talking about dealing with in camera? Are we talking about 1, 2, 3, 4, 5, or what is the number?
I can give you the exact number. Approximately 19.
19?
19. I was not exaggerating when I stated to the court that this is a case that's employing multiple disciplines in forensic sciences. I think every single aspect of forensic science is being utilized by the state, and to counter that.
Let me ask you this. On your current defense witness list, how many experts have you listed besides Dr. Henry Lee?
I think just one other.
Ms.
Drain, you look like you want to say something.
I believe I can accurately answer that. They had listed a Dr. Kobolinsky. They've not alerted us to the fact that they're not going to use this person. The only thing that we've been told so far is that the experts that have been listed have not completed their work, which is why we haven't set them for deposition. The other expert is a computer expert, somebody who took a mirror image of the hard drive. I don't know if that person is completed with their work or has completed their work, or if they're going to ask for more costs as part of the 19. So those are the listed expert witnesses. There are other witnesses who have made themselves known publicly on television, who had come to the crime scene, as Mr. Baez had indicated to the court earlier, but they have not actually appeared on the witness list. So there are individuals who have already made themselves known who may now seek to try to hold confidential.
Your Honor, there was also a number of forensic expert witnesses that were announced by counsel in open court at a hearing, and I believe it was December the 12th of when the day after the body was found. The counsel announced a list of experts. So those obviously are not, though they have not been listed on the witness list, they have been made known publicly. I don't have all those names in front of me. I know one of them was Kathy Wrights, forensic anthropologist. One of them was an entomologist whose name escapes me at the moment, was announced, and maybe others, but there have been a number of public statements of other experts being involved.
I can respond to that.
Yes, sir.
There have been, as part of our motions, arguments made with these experts that have come out in open court, but I think the court is getting a little more detailed as to its inquiry as to what these individuals have actually done and not done, and that, I believe, is what should be done in camera. As to their names and things like that, that's one thing versus the detail that I anticipate, Your Honor, asking me, and me basically telling giving the response as to what, in fact, that they're doing.
I'm just going to utilize the case that you cited in your motion, Lavender versus State, the 5th District Court of Appeals case found at 889 7th 2nd 882. And in that case stands for the proposition, and I quote, However, an indigent defendant's right to appointment of an expert is not unfettered, and it is obviously limited to those situations where the expert's testimony is relevant and necessary. So the standards you have to meet is you have to show that it is relevant and necessary. Usually, the cases where you go in camera is when you're seeking some psychological evaluations where you want to look-see that mostly everyone does in death penalty cases, and that's done early on. And I would suspect that at some point, Ms. Lyon may have already done that at some stage, because that's one of the first things that comes up in the 3851 proceeding. But what is the state's position on the in-camera?
The issue of in camera itself is not necessarily our concern. Our concern is whether or not those are going to be ex parte in camera hearings, simply because the gentleman from the JAC certainly doesn't have the foundation or the background that I would, or that Mr. Ashton or Mr. George would, as to the progress of the case, things that we know that have been brought out in public, that have been in discovery, in hearings, in depositions, different communications. So he's at a disadvantage, and we believe that we can assist the court without interfering in their request with some of the information as it relates to the volume of work that has been done, exists out there to review, things of that nature. So ultimately, we do object to ex parte.
Okay. Mr. Baez, I'm not interested in asking you what these experts have opined at this point. What I'm interested in is if you're going to have experts, let's say y'all have said an anthropologist, and I imagine that person would testify as to something about the skeletal remains. Maybe how long they've been there or what. I don't know. You probably could make a very good argument without saying much as to why it's relevant and necessary. You have a body that's skeletal, and somebody needs to testify about that. The state may have an anthropologist. I don't know. Do you have one, Ms. Drain?
We do.
And that person is going to testify to A, B, C, and D. So those are things where you could easily say that's relevant and material. So that does not need to be in camera.
We can make an attempt, Your Honor. I certainly don't want to make the court's job more difficult. If we can go down through our list, I can bring them up as best as I can. And if there's any further discussion, I can mention to Your Honor our request that it be done in camera.
Okay. All right, this is what we're going to do. We've been going at this since 9 o'clock. It's almost 10:30. We're going to be in recess to a quarter to 11. And folks, we need to go ahead and go through this list, because if these are folks that's going to testify, I'm not interested in any work product. All I'm interested in is I need an expert for this. This is the person that I'm going to utilize. JAC can respond. If you got an out-of-state expert, they're going to ask why. And my question is this someone new, or is it someone that has been on the case from the beginning? Then the next question is, how much work have they done? I mean, is it 60% complete? If it's 60% complete, then it makes no sense to go hire somebody to have to come in and do it 100% when the only thing you're going to have to pay for is the remaining 40%. Those are the only things that I'm interested in. So kind of narrow your list down. We'll be in recess till a quarter till an hour.
Thank you, Judge.